Section 29 introduces significant changes to the Enhanced Research and Development Intensive Support (ERIS) scheme specifically for Northern Ireland companies. These provisions, which came into effect for claims made on or after 30th October 2024, replace the Research and Development, Chapter 2 Relief, Regulations 2024. The most substantial change affects Northern Ireland companies that trade in goods or electricity. Rather than being subject to the previous fixed $250,000 cap on ERIS relief, these companies are now only entitled to enhanced relief to the extent it qualifies as de minimis aid under EU state aid regulations specified in the Windsor framework. This change aligns the scheme with the UK's international obligations while addressing Northern Ireland's unique market conditions. For calculation purposes, the legislation defines additional relief as the difference between what can be claimed under ERIS and what could have been claimed under the R&D Expenditure Credit (RDEC) scheme. This differential approach means companies must perform this calculation to determine their maximum allowable relief under the de minimis rules. Companies not involved in trade of goods or electricity can be exempted from these restrictions, but must notify HMRC in writing of their wish to be exempt. For qualifying companies, the Act also removes certain restrictions on overseas expenditure related to contractor payments and externally provided workers that would otherwise apply under ERIS. When submitting claims, affected companies must provide a statement confirming any additional relief claimed would constitute de minimis state aid, along with the total value of such aid received from the UK during the 3-year period ending with the claim date. These modifications were implemented to balance Northern Ireland's specific market requirements with the UK's commitments under the Windsor framework as part of the EU withdrawal agreement